All rise. The Supreme Court of Guam Confession, Honorable Robert J. Torres presiding.
Day, you may be seated. Good morning. Will the clerk please call the case?
This is Supreme Court case number CVA 23-015, Goodwind Development Corporation, Plaintiff Appellant, Cross Appellee, v. West Bay Corporation and 21st Century Corporation, Defendants Appellees, Cross Appellant. Appearing for Plaintiff Appellant, Cross Appellee, is Attorney Anita P. Areola. Appearing for Defendants Appellees, Cross Appellant, is Attorney Louis J. Yanza. The panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Areola reserves 7 minutes.
Heck, give me 1 second. We'll try to getting some feedback here. Let me just test. Still getting
Test. Can you hear me, Liam?
Yeah. It's the microphone is off, but it's here. That's the problem. Yeah, it's in. All right. Testing.
Test. 1, 2, 3.
Test. Test. Testing. All right, we've got it. Thank you. Sorry for the interruption. All right, the case has been called. No, it's still. It's been tested.
It's on.
Test. Hopefully it's good. All right, the case has been called. Miss Areola, you may proceed. Sorry.
Mr. Chief Justice, may it please the court. The issue presented in this case is one of first impression before this court. It is not, however, the first time that a Guam court has addressed whether a statute of limitation waiver is valid and enforceable, and the party signing it is bound by it. In Gita versus Mayu, the appellate division of the District Court of Guam addressed the exact same issue and held that under fundamental contract and guarantee law, Mr. Mayu was bound by the limitation waiver clause in that case. Under People versus Kanga, this court held that decisions from the appellate division are binding precedent upon the trial courts of Guam. They are considered by this court as persuasive authority. Further, this court will not divert from such precedent unless reason supports such deviation.
So, Ms. Areola, I would like to examine the Mayo case just in reference to what was reviewed at the time. This was in 1970. well, the case did not did not discuss, this was former CCP section 337, which is the statute that preceded 11303. And 11303 has to do with the statute of limitation, and that specific section was not discussed. And also when a cause of action arises, that's in 13 GCA 3122. And I'm sorry, the 11101 is the former CCP 337. So if the Mayo decision didn't discuss the interplay between what was the statute of limitation at that time, 4 years, when a cause of action arises, in terms of, and that it would be subject to the time periods prescribed in the statute, which is 11101, unless as 13 GCA 3122, these are the interplays of the statute that says a special case exists, the circumstances that a special case exists. Now, the Mayo decision didn't discuss this interplay. So is that precedent really persuasive in reference to us looking at these statutes for the first time on appeal?
It is persuasive because the decision in that case, while we do not have the exact waiver language from that case, the decision makes very clear that it was a waiver of the statute of limitations. The first page on the guarantee that was involved there specifically stated that Mayo was waiving the statute of limitations under that particular code section.
But
And
didn't that case more specifically address the argument that the defendants in that case did not read the provisions, and therefore they should not be bound because they were not aware of it?
It did. That was one of the issues that was decided in that case, but the court didn't just rest there. The court went further and said, I mean, its ultimate holding is under, and I'm quoting, under fundamental contract and guarantee law, Mr. Mayo was bound by the limitation waiver clause in that particular agreement. And that
But did the court specifically address CCP, I'm sorry, 337, it's a 1970 statute, because that is the specific provision that preceded 11101, which is really 7 GCA 11101, which is really what is before us in terms of the 4-year statute of limitations and whether it's subject to being waived, and whether there's any provision under Guam law that would allow for it.
The court did not specifically address that particular provision of the statute. However, the fundamental and ultimate holding of the case, and it's very clear in black and white in that case, is that they upheld the waiver of limitation, statute of limitations clause in that case.
But
Now,
did they cite any laws that directly address the issue of the validity or enforcement of the statute of limitations in that case? I don't think they did.
they did not, but Your Honor, the issue that's involved in this case is pretty much on all four squares as that case. In fact, some of the facts of that case are uncannily similar to the ones in this case. There was a guarantee in that case. They waived the statute of limitations. He said he never read the guarantee. That is very similar to what is happening here. And Your Honor, while I understand that you might want to go into and delve into the statute of limitations and, when it commenced, when the statute of limitations begins, all of that can be answered in this case. In this case, the issue really is, can the court uphold a limitations waiver that is agreed to by parties in a contract? That is the
And I
ultimate
agree.
issue.
And then that's the reason why I raised the point, is that if the Mayo decision did not address the pertinent statutes, that it really is a first opportunity for us to see the interplay between 11101 7 GCA 11303 and 13 GCA 3122, which to me would be something for us very much that is what is at play in this case.
I do not necessarily agree because we do submit that there's no reason to deviate from the appellate division's decision in
But
May.
why would that not be the case? So when you readily admit that the Mayo decision did not address former CCP 337, which is at the heart of the analysis in reference to determining whether or not the statute of limitation is subject to waiver and whether or not there are any provisions under Guam law that provides that this is allowed under certain special case circumstances.
Because whatever the statute of limitations is in this case, it's going to be the statute of limitations regardless. The question here is really whether that statute of limitations can be waived. And there is another Guam statute which allows the waiver of parties' benefits under a contract so long as it does not violate public policy. And so the ultimate issue here before the court is really whether the limitation waiver by the parties in these promissory notes violates public policy. And
But
we
doesn't
submit that
it
it
do
does
that?
not.
Ms. Ariella, doesn't it violate public policy?
No, we don't think that it does. The statute of limitations, definitely, we agree that that is a big issue. It is a form of public policy that the courts are very concerned about and that we should all be concerned about. But the countervailing public policy, particularly in this case, is the public policy of, and the paramount policy of allowing competent parties to freely contract.
But isn't statute of limitations not just an individual right that there is some interest on the part of governance that stale claims not continue to be left unaddressed, that there is an interest on the part of the public that we bring finality of decisions, we bring it the definite contests to a conclusion?
That is definitely a very strong public policy reason. An equally strong and countervailing public policy is the freedom of contracts to contract freely and bargain away their consideration.
And what's to
This-
prevent then a waiver to be included in every promissory note?
There is nothing to prevent that, Your Honor, except that we are arguing that in this case, there's a middle path. There is the public policy relating to statute of limitations and upholding them. There's also a public policy relating to the freedom of parties to contract. What we are arguing is that in this particular case, the limitations waiver should be upheld. Why? Because the commercial notes contain these provisions. These are two commercial loans totaling $870,000 to acquire an interest in a company that purchased a parking garage in San Francisco. No interest was charged on the loans and no payments were required to be applied to interest first and second to principal. Third, there is no maturity date on both loans. Fourth, payment is due within 30 days of demand. Fifth, there are no personal guarantees that were required by the parties. And sixth, there is no collateral or property required to secure the loans. Taking the notes as a whole, the terms constituted significant and substantial consideration for the borrower's waiver of the statute of limitations. They could not have obtained the same kind of highly favorable terms from any other bank or any commercial lender. The terms agreed by the parties were extremely reasonable and favorable to the defendants.
Was that really an arm's length transaction? Aren't these all related parties that had a purpose, and that was to address investing, making an investment, but following the recommendations of their auditors of how best to minimize their taxes, everything, of course, perfectly legal. But in these are all related parties trying to come up with a structure that will minimize tax implications in an investment. So when you argue that these are all specifically bargained for provisions in return for the waiver of the statute of limitation. That doesn't operate in a vacuum under the facts of this particular case.
Well, Your Honor, it actually works to the opposite effect as well. These may have been related family members, but we also have Rowena Tan and Joseph Chua, who were officers and directors of Goodwin at the same time that they were shareholders and officers of West Bay and 21st Century. And so they had the ability to call these loans in due when they were officers and directors. And in fact, Mr. Chua was the president of Goodwin for several years. And so we believe that it was an arm's length transaction. They had the ability as officers and directors and shareholders of Goodwin to call in these notes at any time. So it works in their favor and to their detriment, but more in their favor because they were in control of Goodwin. They could have called these notes at any time. And so that's why we believe that this is a very good reason and a foremost reason for the courts to uphold the limitation waiver in this case. They voluntarily waived.
Going back to the public policy
Yes.
issue. If we look at the facts of this case, everything's at least 11 years old. At least one of the primary witnesses to the transaction is no longer able to testify or give evidence. Doesn't that illustrate the point of having a limitation on when actions can be brought?
We do not necessarily agree with the characterization of Mr. Tan's health in that way. That was simply an allegation in the counterclaim. But Your Honors, we believe that the statute of limitations did not commence in this case until Goodwin made a demand under the note. Under promissory notes, there are two instances in which the statute of limitation may commence. One is upon execution of the note, and the second is upon a maturity date of the note. There is no maturity date or term of these two notes, but there is a provision right after the waiver of the statute of limitations, which states that the lender may extend the term of the note without consent and without notice to the borrowers. Again, another extremely favorable position, term and
How do you
condition for the
reconcile that with
bondholders.
section 3122, 13 GCA, that a cause of action against a maker or except accrues in the case of a demand instrument upon its date, or if no date is stated, which is this case, on the date of issue, and the date of issue is May 2011.
And we disagree with that, Your Honor. We believe that because Goodwin did not make the demand until 2022, that commenced the statute of limitations. And we say
But
that
what's the
because
maturity date that's stated on the face of the document?
there's no maturity date stated on the face of the document.
So how
but
do you
there is-
reconcile that if no date is stated?
Because there is that provision in the note that allows the lender to extend the note whenever it wanted. And again, Your Honors, who was the lender in this case? Who was in charge of Goodwin and in this case? That would be Rowena Tan and Joseph Chua. They allowed the extension of this note. They allowed repayment to continue ad infinitum because they were in charge of Goodwin. And so, they can't have it both ways. They can't say, the promissory note, the statute of limitations commenced upon execution, and then at the same time, take advantage of a provision
Then wouldn't
that
that
allowed them.
support
to
Justice
extend it.
Merriman's concerns that, there needs, in terms of public policy and the reasons for a statute of limitations? Of course, we're debating here when it starts and,
Mhm.
but that the public policy is that there needs to be that certainty in relations to causes of actions, and that we can't keep it pending for an infinite period of time, like you said, continuously being continued, that there is a rationale why there is a general concern that we have certainty and finality in references to disputes and for how long it can be acted upon.
That is certainly the salutary effect of statutes of limitations. But what I'm asking the court to do is to look beyond simply the waiver provision in this particular promissory notes, and to look at the promissory notes as a whole. And if you look at them as a whole, this was clearly designed to allow the borrowers the maximum extent of time to repay this loan. And if you even read, the counterclaims that was asserted by the defendants, they also recognized that it was going to take several years to recoup their investment in the San Francisco parking garage project. And so that is why the parties agreed to extend the notes and also to allow these particular provisions. And I understand the concern about the statute of limitations, but there is also another concern about not interfering with parties and their right to freely contract.
But isn't there an express statutory provision under Guam law where if it was a law established for a public reason or public policy, that it can't be contravened by private agreement?
That is one of the statutes that is authorized.
So if we have the public policy reason for doing, I know you emphasize, it's freedom of contract, and while it's true, anyone should be able to waive an advantage of a law intended for their benefit, when there's a public policy reason that's established, generally it's can't be contravened by a private agreement. And aren't you asking us to adopt what is really a minority position on statute of limitations and a public policy reason for having them?
So let me address your first question, Your Honor. So there is definitely a public policy in the statute about the statute of limitations. But when we talk about public policy and we look at all the decisions involving public policy, it's not just a statute. It's the history and experience in Guam that decides what public policy is. And at least with this court, I think I can safely say that all of the breach of contract and other contract cases that I have read are firmly entrenched in upholding parties' rights to contract freely. That would be in Burkhart versus Miranda, Hemlani versus Hemlani, the the PD power plant case, and other cases involving breach of contract, where this court has firmly stood in favor of upholding parties' rights to contract.
Yeah, but in those particular cases, we weren't confronted with weighing conflicting concerns. In this particular case, individual rights to contract as compared to the public policy of trying to bring finality and certainty to disputes of parties, and that it doesn't remain pending for an indefinite period of time.
Not this particular case and not those particular public policies, but certainly there have been other public policies that the court has taken a look at. I'm sorry, it's YTK is the decision that I was trying to find, where, the court has, looked at different agreements and upheld certain provisions, against the face of challenges to those provisions. And as I was answering Justice Torres's question, we have to look at public policy not in a vacuum and not just solely at one statute. We have to look at it in terms of what is the history of the public policy of statutes of limitations in Guam, and what is also the history of enforcing public people's contracting rights in Guam. And I would submit that this court has a pretty strong record of upholding parties' rights to be bound by the terms and conditions of their contract. Your Honor, the second question that you asked was, aren't you in a minority position? I would submit that of the 15 jurisdictions that have addressed this issue, yes, all of them have decided that a limitations waiver is not enforceable, but that's 15 jurisdictions out of, 54, 53 of states and territories that are involved. And so the other 3/4 of the states have not, addressed this particular issue. I did cite the one Kansas case for Security Bank versus Buene, which in that case is frankly pretty much on all squares with this case as well, where there were promissory notes, there was a waiver of the limitations issue, no payments were made by the borrowers, and the court held that under their law, there is a paramount public policy of upholding the party's right to contract. And so the waiver provision, we believe, is not contrary to Guam's public policy. Upholding it is consistent with the important public policy of not interfering with the freedom to contract. We have also asked the court for leave to amend if the court decides that the case is barred by the limitations waiver provision, and they're going to strike that provision down. We request.
How would you amend it if the provisions of the agreement in terms of looking at the various statutes that apply in terms of that if no maturity date is stated in the note that it's the date of issue, and that's May 2011, and 4 years after that is May 2015. How would any amendment cure the apparent violation of the statute of limitation when the suit was not filed until 7 years after 2015?
We would amend the complaint to allege equitable tolling in this case, and that would be because Rowena Tan and Joseph Chua were insiders. They were shareholders, directors, and officers of West Bay and 21st Century on the one hand, and of Goodwin on the other hand, while being at the same time shareholders and directors of all three companies. They had the power to call these notes in and to demand that that payment be made, and they refused to do so. In fact, it was to their benefit not to do so. They are both savvy, knowledgeable business people who knew what they were getting into when they signed the notes. And under the notes, as I've mentioned before, Goodwin, under the provision of both notes, could extend the time for repayment of the notes without consent or notice to the borrowers. And we would add this particular provision as being part of the ability for West Bay and 21st Century shareholders and directors to grant themselves extensions of time to pay under the notes.
I want to explore that equitable tolling
right.
issue. I mean, my understanding is that equitable tolling would be raised because the defendants had asserted for the first time in their counterclaim that the Century note was paid off by November 30th, 2011 through some sort of a payroll deduction of the salary. And so even if the current management of Goodwin wasn't aware of that claim until the defendants filed their counterclaim, if Goodwin believed that the Century note had not been paid off and wanted to bring a cause of action to demand payment, why shouldn't that, if it was paid off or arguably paid off since 2011, why wouldn't then that the date still then track at the worst till November 30, 2015?
We don't agree that Mr. Chua had paid off the 21st Century note by payroll deduction. We have no evidence of that. We've not seen any information. That's simply an allegation in their counterclaim, and so we don't agree with it.
But isn't that the basis for the equitable tolling? It was that it was told because of this assertion that it was paid off, and therefore, the statute has been told because they were asserting that the loan was paid off, but now you're disputing that?
I'm sorry, Your Honor, are you?
Yeah,
Yeah.
I thought your argument was that the statute of limitations was equitably told because they asserted for the first time in their counterclaim that it was paid by virtue of a salary deduction.
Yeah, no, Your Honor, that's not what we asserted. We were not asserting equitable tolling. What I argued in our brief is that the fact that they are claiming that 21st Century note was paid off, and they further claimed in their counterclaim that they knew that Goodwin was asking for it to be paid off within a year. That was evidence and an admission from them that they knew that Goodwin was going to demand payment on the notes at some point or other. And you can't read the two notes separately. So it wasn't equitable tolling. It was an admission on their part that they knew that, one of their basic claims is that, we didn't know until, they filed suit that, they were going to demand collection on these notes. Well, of course they knew. They said so in their counterclaims. They said that Goodwin, was demanding payment on the 21st Century note, and they paid it off within a year. That's an admission to us that they knew that Goodwin was going to demand payment at some point, and it renders or negates their claim that there wasn't going to be any demand for payment by Goodwin at all. So it's not an equitable tolling issue. It's more an admission by
Well, I
them.
thought that you were arguing that you were entitled to amend the complaint to show that the statute of limitations was equitably told.
That is something that we want to add. We do want to add the fact that they knew that Goodwin was going to demand payment. And that's exactly one of the reasons why, is because they admitted that Goodwin was seeking payment. First note within a year after it was executed.
What about the extrinsic evidence that you say that the court considered in making its decision? What specific extrinsic evidence did the court improperly rely upon in dismissing the claims? I mean, I know it cited to some facts earlier, but the court explicitly stated that it would disregard those facts that weren't included in the original complaint. And so I wonder what facts the court referenced that specifically it relied upon in dismissing the claims based on the statute of limitations.
So, Your Honor, exactly the facts that we were just talking about. In finding a fact 4 of its decision, the trial court specifically made a finding of fact that the 21st century note was paid off. We argued that it was not. And they, in finding of fact number 3, they also talked about how Rowena Tanchul was the nominee shareholder on behalf of GDC. We contest that. We object to those. The trial court may have said in its decision, "Oh, I'm not going to take into account those facts," but it clearly did. It specifically made findings of fact based on allegations in the counterclaim, and in fact, they cited the allegations in the counterclaim, in which upon which they relied. Now, under that scenario, under Rule 12C, there's only 2 options. One is you disregard the evidence, and 2 is you convert it into a motion for summary judgment. There's no in between here. And what he did was he failed to convert it into a motion for summary judgment and failed to give us notice so that we could give countervailing affidavits or declarations opposing these particular facts. I note that the defendants have argued that, if there was any, consideration of these particular facts, it was only harmless error. But that is not a standard that I have found in any decisions, or certainly not from this court, where we're talking about a motion to dismiss and considering extraneous evidence. That is not a standard that I found anywhere. You either consider the evidence and you convert it to a motion for summary judgment, or you disregard the evidence completely.
Well, that may very well be the case. I mean, when you look past the court referencing, making references to statements in the counterclaim, but look at the basis for the court's decision in granting the 12B6 motion, I thought that the court was pretty clear that, there's no maturity date on the note. Therefore, in the statute is the date of issue. 4 years after that is 2015, and the suit was not filed until 2022. So that was the basis that the statute of limitation on the face of the note had expired, and that there was no provisions under Guam law that allowed for its extension.
Except, Your Honor, that in their decision, they do talk about the fact that the allegations in the counterclaim, he does talk about the allegations in the counterclaim, and in particular, the whole San Francisco, garage project, and as well the waiver.
But how did that factor in to the court's specific conclusion as to the reason why it is dismissing? It may have made references, but what were those references factored into the court's reason for granting the 12B6 motion? It may have, made these references, but I'm trying to see how those references factored into the court's rationale for dismissing.
I think on page 6, I think it says very clearly that they were looking at when the statute of limitations began, and they talked about how they relied upon the I'm
You
sorry,
can-
is that my time?
Yeah, you can finish
Oh,
answering.
okay, thanks.
question.
And they talked about how that time was based upon finding of fact 4, when the defendants alleged that the note has not been paid since November of 2011, and when the Century 21 note had been paid within a year through payroll deduction of the execution of the note. Again, when you when you make findings of fact and you state that in a decision, whatever the reason of the trial court judge in making those findings of fact, he did allude to and consider extraneous facts.
Thank you, Mr. Wright.
Thank you. I'll give you 5 minutes for rebuttal and to answer the appeal.
I appreciate that, Your
Yeah,
Honor. Thank
even
you.
though you've exhausted 30 minutes. Mr. Yanza?
Mr. Chief Justice, may it please the court, counsel for Goodwin. This court should join the vast majority of jurisdictions that have held that an indefinite waiver of the statute of limitations is unenforceable as a matter of law and as a matter of public policy.
Ms. Ariola argues that the waiver clause is a limited waiver clause here and should not violate public policy because even though it waives the benefit of the statute of limitations, it says to the extent allowed by law, and defendants are permitted to raise other challenges to the note.
Well, I guess the safety valve that she's referring to is the language to the extent permitted by law. But before I even reach that issue, Ron, I want to just point out to the court that an indefinite waiver of the statute of limitations is a violation of public policy. Now, if we go back to this indefinite, language of to the extent permitted by law, I still don't think that it does not violate public policy. It still violates public policy because we don't know where this extent permitted by law holds or extends the statute of limitations. We are 13 years after the fact, after the promissory notes were signed, and they're still trying to go after my clients for those prom notes. So I don't know how this extent permitted by law limits the statute of limitations waiver.
Well, I think the
indefinite.
argument, as I understand it, is that extent as permitted by law is the recognition of the rights of private parties protected by statute, that they should be free to enter into agreements as they choose. And as Ms. Ariola has pointed out, these are sophisticated parties that should be left to their arrangements and held to the consequences of their actions.
Well, first of all, yes, Goodwin proposes a competing policy to weigh against the important public policy and private purposes served by the statute of limitations, that the individual parties are freedom to contract. But a lot of courts have addressed this issue, and they've said that really it's not enforceable because a waiver of statute of limitations is perpetual in nature. And most of the time when these parties sign these waivers, it's by improvidence, ignorance, unequal bargaining power, or the party's intent never to enforce such provisions. Second, a lot of courts who have actually addressed these waivers have said that the party's freedom to contract is significantly outweighed by the important public policy against the waiver of the statute of limitations. And then going back to the parties being sophisticated parties, well, that goes against at least the defendant's allegations in the counterclaim, which is taken in light, favorable in light of the pleader, that these were, yes, they are sophisticated parties, but this was not an arm's length transaction. Certainly, when the parties are contracting with each other, the court should also look at whether or not there's a confidential relationship between the parties. This is a family business. Rowena, who is the principal of West Bay, imposed great confidence in Goodwin and her father to the point that whatever Goodwin's officers asked her to do, she followed. She's the oldest daughter of Lucio Tan. What daughter is going to say no to the father, who's a wealthy businessman and a billionaire? So the fact that they may have been business people and wise, but this was not an arm's length transaction. And as the court has also pointed out that 20 GCA 1505 says that you cannot contravene a public policy by a private agreement.
What about the argument of learning for the first time that there was this supposed payoff in the counterclaim that the Century note had been paid off, and so they should have a right to amend the counterclaim. I mean, amend their complaint to include equitable tolling.
I don't know how the Century note. Well, you have to take the Century note and the West Bay note in two different views. The defendants have never refuted the authenticity of the Century note. They have admitted that they borrowed $125,000 and they paid that back. With regards to the West Bay note, they've always refuted the enforceability of that note because that was sort of their scheme to avoid taxes on paper. They needed this note to show the auditors that when it's tax time, that Rowena was in fact the West Bay owner and had signed off on the promissory note on behalf of West Bay. So I don't know how equitable tolling will assist Goodwind in terms of the Century note. The Century note has already been paid off and we've never refuted that document. We only refute the West Bay note. With regards to Goodwin's request for leave to amend, I don't think it will help them because it would be futile. This is a demand note. There's no maturity date. There's no date when they're supposed to collect. And because of that, the SOL begins on the issuance date, which was in May 2011. So if we assume that May 30, 2011 is when they signed the note, they had until May 30, 2025 or 2015 to file action to collect on that note, but they never did. Now, in their brief, they're saying, well, maybe we should amend the complaint so we can find out whether or not we made a prior demand. A prior demand beyond the SOL does not extend or toll the SOL. Once you're beyond the SOL, you cannot collect on that demand note. I asked the court to join the vast majority of jurisdictions because should this court allow this waiver to be enforced, then as a matter of routine, all these creditors, all these lenders, all these private lenders will be inserting these waivers as a matter of routine. And we may not see it now, but in 5 to 7 years, 8 years, we'll see a lot of these claims, stale claims, being collected on by creditors. I will now move on to the defendant's cross appeal.
How do your fraud claims meet the Rule 9B particularity for identifying the who, what, when, where, and how? It seems like there have been some general allegations, but I mean, even in terms of the specificity, if you look at, for example, even your proposed amendments to your counterclaim, they don't seem to connect the dots in terms of identifying the specific persons who were responsible for Goodwind in engaging in the fraud.
With regards to the proposed amended counterclaim, that was premised upon the first counterclaim, but with regards to the counterclaim, all that was needed was the plaintiff to provide a short and plain statement showing that he's entitled to relief. Complaint.
I don't think that's necessarily the case when you're pleading fraud. I mean, Rule 9B is pretty specific in terms of what's required when you're doing fraud. You have to be stated with particularity. Yes, you can aver generally the malice or the intent and the conditions of the mind. But I mean, in order to adequately defend against allegations of fraud, and intentional misrepresentation, there has to be more than just general statements about, being misled. You've got to be able to, there are multiple actors here from a corporation where they were officers and agents, and I think, it would seem you'd need to identify what the role was of the employee who was responsible for the scheme, how they misrepresented, and including what the damages were that resulted from it.
Well, I think, Your Honor, that we did allege with sufficient particularity the who, what, where, when, why. The who is Goodwin, obviously that's a corporation, and who was acting on behalf of Goodwin.
Yeah, but which officers and agents of Goodwin? I mean, I don't think you can just say, well, Goodwin, I mean, who in particular in Goodwin was responsible for did those actions at the time of the alleged fraudulent misconduct?
In the counterclaim, we actually alleged that it was the CFO, Ong Lau, that was leading this project. And then we've always alleged other officers, well, we've also alleged that some of the tax advisors were part of the scheme. But with regards to who, it's Ong Lau on behalf of Goodwin, where that was.
Yeah, but what did he specifically do? That I don't think is apparent from your counterclaim.
Well, he was the one who represented to the defendants, or at least to Rowena, to sign off on the West Bay note that would not have to be repaid because this West Bay note was only for tax purposes and on paper. And that this whole scheme, of course, was about going into this garage project that after that, then they turned around after they filed this suit. Now, the defendants see that they've been committed by fraud by the plaintiffs. First, they say that you don't have to pay this note. 11 years, 12 years later, now they make a demand. Then 13 years later, they now file suit. So I think we've alleged with sufficient particularity of who, what, where, when, why. But if we have not, and if the court believes that we have not, then we should then ask the court for leave to amend the fraud claims on the counterclaims so that we can, remedy the deficiencies in the allegations.
Mr. Yanza, if you prevail and the complaint is dismissed, is there still a fraudulent claim? I don't see any damages then.
That is correct, Associate Justice Merriman. Should the trial court's decision on dismissing the Goodwin complaint be affirmed, most of the counterclaims will be dismissed. The fraud claims will be dismissed. The negligent representation claims will be dismissed. I believe only, Your Honor, maybe perhaps the breach of contract and the unjust enrichment claims, because they've now, at least Goodwin has now walked back or reneged on its promises to pay for its share of the garage expenses and the garage loan. So that's still outstanding.
Can the unjust enrichment claim stand alone as an independent cause of action if the fraud claim doesn't survive?
I believe so, Your Honor.
Why?
Because at least for the Century note, they can't go back and say that,
But aren't they based on the same allegations of fraudulent conduct that support the independent claim of fraud? So why wouldn't that be dispositive of the unjust enrichment claim as well?
Well, because of the unjust enrichment claims, if they're going to renege on their promise to pay for their fair share of the operating expenses, they should not, benefit from them not paying into the garage loan, or for actually paying into the West Bay capital, because it was their own money that put in it was Goodwin's money that paid for the $750,000 into SFOB, which is the owner of the garage.
So if that was the case, how is Goodwin unjustly enriched?
With regards to the Century note, I guess if the court dismisses the complaint, the Century note is gone. For the West Bay note, they still have, I mean, for the SFOB operating expenses, they should not be unjustly enriched by not paying for their fair share of their expenses. There was an arrangement between the parties that if SFOB was short on paying expenses, Goodwin would pay in, right? And of course, Joseph Chua and Rowena has also been paying into those SFOB expenses. So the parties' agreement since the beginning was everyone's supposed to pay for their fair share of the expenses. Now that Goodwin has walked back on its promises, they should not be unjustly enriched by saying we're not going to pay for those expenses anymore. So they should be held accountable for their own fair share of the expenses.
But if I'm not following, how is it that Goodwin doesn't continue to be on the hook if it's part of the investment?
Well, I mean, I guess that's a good question, Chief Justice, Associate Justice Carbolito, but the problem is they walked back on their agreement now that they filed suit. So now we can't just sit back and say, okay, we hope that you will pay for your fair share of expenses. When now they've said to us, we're not going to pay for it. So they should not be unjustly enriched by not paying for their own expenses.
I don't follow that, but you can move on.
Second, Your Honor, the trial court erred when it dismissed the breach of contract claims, the breach of the covenant of good faith and fair dealing based on the parole evidence rule. The parole evidence rule bars extraneous evidence if there is a written agreement between the parties, which was supposed to be the final and complete embodiment of the parties' agreement. Here, the trial court clearly erred when it found that the no oral modification clause was a fully integrated clause which prevented extraneous evidence from contradicting the terms of the note.
There are generally just two exceptions to the parole evidence rule. One is the validity and one is the fraud exception. So I'm trying to understand why either of those exceptions would apply here to the breach of contract claim.
Okay, yes. Well, for the validity of the document in question, it's a fact in dispute. Obviously, the note, the West Bay note is a fact in dispute.
Right, but if you're going to bring a breach of contract claim, that rests on the premise that the contract is a valid contract. And the validity exception is seeking to establish that the contract is void or voidable. So I don't see how you can reconcile applying either of the exceptions to the parole evidence rule and why the parole evidence rule would not bar the breach of contract claim, because that claim rests upon the premise that the contract's a valid contract.
Well, the trial court made an error saying that the instrument itself was a fully integrated instrument. That was based on the no oral modification clause. But I think the parole evidence rule has a broad exception, which is the fraud or the validity of the document in question. We've always challenged the document in question, even though extraneous evidence may contravene or contradict the terms of the instrument in question. We're not showing it to contradict the document. We're just showing that the document has no legal effect.
But you're saying that these agreements that aren't included in the written terms of the note, right? I mean, clearly they're not. So they constitute parole evidence that you're seeking to bring in.
Yes.
And there's two exceptions to the parole evidence rule, the validity and the fraud exception. And so those exceptions, I don't think likely don't apply in this case, either of those exceptions. And so if the parole evidence should be excluded, and especially since the breach of contract claim rests upon, you're not challenging that the contract's void, you're trying to say that a valid contract exists between us.
Quite contrary, Your Honor. I mean, I'm saying that, I disagree.
I mean, isn't that what a breach of contract? You're saying we have a contract and so that a valid contract exists between us.
Yes. That's Your Honor is referring to the extraneous evidence, correct? right?
Yeah, I mean, we have the validity exception and the fraud exception to parole evidence, right?
Right.
The validity exception allows you to come forward and challenge the establishment of a contract and say it's void or voidable. Here you're saying parole evidence should be admissible to say that we have this contract that exists to allow them to pay for their share of the expenses, or this is part of that contract, right?
No, not necessarily, Your Honor. I'm saying this extraneous evidence should be allowed to show that the prom note is no longer enforceable, because that prom note was just a sham note for the parties to avoid a high tax liability. The extraneous evidence will
But
prove
that's,
that this was a sham
reference,
note.
that reference fraudulent claims. That doesn't reference a breach of contract.
Contract, yeah. That's the fraudulent claim issue. I mean, we're talking about your counterclaim for breach of contract. You're saying that there's a contract that we have that they have breached and we are entitled to damages, and the parole evidence rule doesn't bar doesn't apply, because the trial court found that the parole evidence rule applied and there was no breach of contract claim.
Well, I disagree, because if we go by that logic, then every document or every instrument would then become enforceable without referencing to a side agreement where the parties have said that this prom note is only to be on paper and unenforceable because we are using this for tax purposes. So I think even outside contracts, extraneous contracts are still admissible to show that the instrument in question is unenforceable, despite it contradicting the terms of the instrument itself. Finally, we don't believe that the defendant's counterclaims are time barred. Here, the plaintiffs rounded up all the fraud counterclaims under the statute of limitations. I have to say that, nowhere throughout the time that the note was executed, notes were executed up until the first demand letter, which was issued on May of 2022, was there ever any notice on behalf of the defendants that Goodwind would begin collecting on those notes? This is in light of the parties' confidential relationship. So they had no reason to suspect that until Goodwind's demand in May 2022, that Goodwind would collect on those notes. No payment was ever made for over 13 years. No demand was ever made. And Goodwind had not ever expressed its intent to abandon the garage investment, refuted ownership in the West Bay, and would not reimburse West Bay for its share of the loan or other expenses in the garage. So I think the court should also look at, the trial court failed to look at the confidential relationship between the parties, because here we have Rowena having a confidential relationship with her father and Goodwin. Finally, we ask that if the court believes that the fraud claims were insufficiently pled, that we have leave to amend the counterclaims. Anything else?
I don't have any further questions. Thank you, Mr. Yanza. Ms. Arioli, you have 5 minutes.
Your Honor, just to clarify, I have 5 minutes on rebuttal and then I go into the opposition on the cross appeal.
No, it's all combined.
Oh, okay.
So,
That was not what I was led to believe when I asked the clerk about the time but that's fine. Your Honor, I think our opposition brief was very clear on the dismissal of the fraud counterclaims, that there are no fraud counterclaims because they are negated by the defendant's own admissions. West Bay admitted in its counterclaims that it failed to read the promissory note. They cannot argue that Goodwin made misrepresentations relating to the note when they did not even read it. There can be no intent to defraud by Goodwin when West Bay did not read the note. And most important, West Bay could not justifiably rely upon alleged misrepresentations when they didn't even know what the note said. So they can't argue fraud claims here when their own counterclaims defeat their fraud claims. Now, alternatively, even if the court doesn't, agree with that particular opposition that we have, they fail to allege fraud with specificity. There is no who, what, when, where, or how that's required by all of the decisions in this court relating to fraud, particularly Titanote versus Calvos Finance Corporation. As Your Honor has correctly pointed out, when they allege that Goodwin made misrepresentations, they said a generic Goodwin. They didn't specify, whether the president, the vice president, any officer or director of Goodwin was the one who made the misrepresentations, when they made it, how it made it, and specifically what it is that they said in terms of misrepresentations. Similarly, there's no specificity in terms of the intent to defraud. There's a generic provision in each of the fraud counterclaims, which basically says that Goodwin willfully, recklessly, wantonly, committed fraud, but there's nothing to say when or how Goodwin and its agents actually had an intent to defraud.
What about the unjust enrichment claim? If we determine that they did not plead the fraud claims with particularity, can that stand alone as an independent cause of action?
No, it cannot. So an unjust enrichment claim is an equitable claim. And so it's either you choose to have a breach of contract, or alternatively, you choose to have an unjust enrichment claim. And so what happened here was in their original counterclaim, they pled a breach of contract. They did not plead in the alternative for a claim of unjust enrichment. But even if they did, the statute of limitations for unjust enrichment is 4 years. They admitted in their counterclaims that they knew all along for many years, for 11 years until they filed their counterclaims, that Goodwin had not made any payment on the San Francisco loan or any expenses on the San Francisco parking garage project. So that is barred by the statute of limitations. I do want to mention about the parole evidence rule. I totally agree with Your Honor's questions. Under this court's ruling in Wasson versus Berg, the parole evidence rule forbids a court from referencing extrinsic evidence to interpret, vary, or add to the terms of an unambiguous contract. We submit, Your Honor, that the promissory notes are clear as can veil in this case. Instead, the counterclaims contain 156 paragraphs that not only contradict the terms of the notes, but completely rewrite the notes. Those are not altering or varying the notes. Those are simply rewriting the promissory notes.
Why wouldn't parole evidence of negligent misrepresentation be admissible under the validity exception to the parole evidence rule, since it's being offered to prove that the instrument was void or voidable?
Because it still relies upon the original contracts, the promissory notes, and whether or not those are valid and enforceable. And so the parole evidence rule should apply because, again, it's varying and altering, the actual terms and conditions of the note. Even if it's negligent misrepresentation, there has to be a misrepresentation that contradicts the terms and conditions of the promissory note. I do want to add one other thing relating to the Goodwin's appeal. So, defense counsel got up and began his argument by saying, if you uphold the limitations waiver, you're going to open the floodgates to all of these creditors being allowed to take advantage of debtors and borrowers. Well, just the opposite will happen if you hold that the limitations waiver is unenforceable. In most promissory notes and loan agreements, there are standard provisions where there's waiver of notice, waiver of dishonor, waiver of extending time to repay, and waiver of amending notes without consent. Those waivers would also be at risk.
Right.
Unless Your Honors have any questions.
All right, thank you, Ms. Ariola. No further questions. The court will take the matter under advisement. We'll be issuing a written opinion and will now stand adjourned.
All rise.